In November of 2008, California voters approved Proposition 8, which defined marriage as a union between a man and a woman in the California Constitution. In May of 2009, a California district court ruled that Proposition 8 violated the equal protection and due process clauses of the 14th Amendment and temporarily prohibited its enforcement. The California Supreme Court ordered that marriage be made available to both same-sex and opposite-sex couples, and because of this, California issued over 18,000 marriage licenses to the same-sex couples. The Hollingsworth v. Perry lawsuit, also known as Perry v. Brown and Perry v. Schwarzenegger, was filed by two same-sex couples against California government officials and supporters of Proposition 8 that modified California's constitution to prohibit same-sex marriage. California's state constitution put Proposition 8 into immediate effect the day after the election. People who supported Prop 8 argued that exclusively heterosexual marriage was an essential institution of our society. Opponents argued that the freedom to marry is fundamental to our society, that the California Constitution should guarantee the same freedom and rights to everyone, and that the proposition mandates one set of rules for gay and lesbian couples and another set for everyone else. In August of 2010, a federal court judge, Vaughn Walker, ruled that the voter-approved Proposition 8 was unconstitutional, violating the 14th Amendment of the U.S. Constitution, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Following the ruling, an appeal was immediately filed with the Ninth Circuit Court of Appeals. The Ninth Circuit panel, in February of 2012, made a 2-1 decision affirming the district court's ruling that Proposition 8 was unconstitutional. The panel was unanimous in their ruling that there was no evidence that Judge Walker, who presided over the district court trial, was biased, or that he should have disclosed that he was gay and in a long-term relationship with another man, which was an argument against his decision made by many proponents for Prop 8. While the Ninth Circuit Court found that homosexual individuals did not have a constitutional right to marriage, they decided the narrowly written decision only applies to couples in California, because California is the only state within the Ninth Circuit Court of Appeals jurisdiction that has granted, then rescinded, marriage equality. The proponents of the ruling then petitioned the U.S. Supreme Court. In December of 2012, the U.S. Supreme Court agreed to hear the case. In June of 2013, the U.S. Supreme Court, by a 5-4 vote, issued its ruling on the appeal in the case, confirming that in accordance with numerous precedents, proponents of the initiative such as Proposition 8 did not possess legal standing in their own right to defend the law in court. Therefore, the Supreme Court both dismissed the appeal and directed the Ninth Circuit to vacate its decision, which had agreed with the district court ruling. The decision left the district court's 2010 ruling as the final decision on Proposition 8. The Ninth Circuit then lifted its stay of the district court's ruling, enabling same-sex marriages to resume.